Intellectual Property Owner's Manual, prepared for and presented at the 2014 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
Good evening, everyone. As you said, I'm Brian Wheelock. I've been practicing patent and trademark law now for 30-some years. What I wanted to talk about tonight is how to handle your intellectual property generally. So I put together and I've given out an IP owner's manual, kind of the basics of how to handle the situations you encounter as an entrepreneur. And I'm going to talk about specifically 9 of the top situations that I think you need to be prepared for. So if you have any questions at any point, I hope you'll just raise your hand and ask them, because I want you to get out of this what you need to know. If I'm repeating stuff, just let me keep going at my high speed as I will, and pass over those. But let's talk about what you need to know, and let's get started. Let's see. Well, I said I was comfortable. Try this. And how much time am I supposed to take to?
You could have 45.
45. I'm glad it's not me.
Yeah, no, it's not you.
Damn, I'm dead.
I guess maybe let's try the arrows at the bottom.
Yep.
All right, sorry, so you're going to have to click. You okay with that?
Yeah, so what do I have to just
So just, if you go to the arrow, put the arrow on the arrow, and
Okay.
then just right-click right here.
Okay, I can
Okay.
handle that.
All right, I'll
Okay.
stay close.
Got the technology mastered. That engineering degree didn't go to waste. So the first thing, and I think the most important thing if you're running in any kind of business that's going to generate or have intellectual property, is to handle confidentiality agreements. You don't want in this environment to talk to anybody outside your company, and maybe not anybody inside your company, without having a proper confidentiality agreement. So my first point is, don't make confidential disclosures when non-confidential disclosures will do. If you've got something and you need to find a vendor, do they really have to know what you're up to? Do you have to say, or I need a dozen widgets? If that's all you need, tell them you need a dozen widgets. Don't tell them what you're going to do with the widgets, why you need widgets. You don't need to reveal anything. So if a non-confidential disclosure will do, don't be telling people your secrets. That applies to anybody, except perhaps lawyers, because we are bound by confidentiality. But your employees, do they really need to know? If they don't know, don't tell them. The second point is, don't make any disclosure of confidential information without some sort of written agreement of confidentiality. You can have technically an oral agreement, but oral agreements, as I say, aren't worth the paper they're not printed on. You need something in writing so you know there's an enforceable agreement. It's also important for the person you're talking to realize, oh gosh, this isn't enforceable. If you ask someone, you promise to keep this confidential, they may mean to keep it confidential, but they forget. But if someone signs something, they realize, uh-oh, I've committed myself. I need to keep this confidential. So do use written confidentiality agreements. The third point, and the most important, is perhaps don't assume that what you need is a confidentiality agreement. I've mentioned it, Bob mentioned it. I need a confidentiality agreement. I'm talking to somebody. No, that may not be the exact agreement you want, and that's why lawyers are hesitant to post forms on the internet, because people think, oh, I'm just going to grab a confidentiality form, this will be all I need. No, that's not it. Why not? It says, if there's any chance that as a result of talking to somebody that they might develop something that relates to what you're doing, then a confidentiality agreement just means they can't talk about it. Doesn't mean they can't use it necessarily, and it doesn't mean that you will own it or have access to it. So why would you let somebody else, a vendor for example, own something that relates to what you're doing when it's based on what you talk to them? So if there's any chance that something could happen, that they could develop something, solve the problem you have, you go to the vendor, I need these widgets, but I need a special widget that does this. You think, well, we can make that widget. Well, if they make that widget, they own it, right? They're the inventors. You inspired the idea, but you didn't invent it. So now who owns the improved widget that you need so desperately for your business? It may not be you if all you have is a confidentiality agreement. So if there's any chance that something's going to work out, you need more than a confidentiality agreement. So just keep that in mind, that getting a form isn't the be-all and end-all. Call up a friend, call up a lawyer friend, give me a confidentiality form. You may not have done yourself a service. The next biggest point is don't make a disclosure to someone you don't trust, even if you have a confidentiality agreement. If they're not trustworthy, the agreement doesn't turn them trustworthy all of a sudden. It's not some magic piece of paper. What does the agreement do? It lets you sue them. It lets you sue somebody who's untrustworthy. That's not a whole lot of fun. I mean, if you can't trust them, don't talk to them. And if you can trust them, it's like Reagan said, trust but verify. Have the agreement in place so you can verify that, yes, your trust wasn't misplaced. So I have kind of a flow chart of if I have information and I need to get it to somebody for a particular purpose. Do I trust the recipient? As I just said, no. Find somebody else. It's a big world. Somebody else is out there who you can trust. But if I can trust them, okay, can I productively confer with these people without telling them my secrets? Can I get what I need without telling them what I'm up to? If the answer is yes, only have non-confidential disclosures. Don't be so hot to tell people what your big secret is. And use a non-confidentiality agreement. What? I know these CDAs, NDAs, whatever they call them, there's actually such a thing as a non-confidentiality agreement. What's that? That's anything we say isn't confidential. Why do I want such a thing? Because if they tell me something, I want to be able to use it. I need a widget. Here's a widget, but we have a super widget. Okay, if we have a confidentiality agreement, I can't tell people about the super widget. I may not be able to do something about the super widget. If we sign a non-confidentiality agreement, they shouldn't have told me about the super widget, but now I know and I can use it, I can put it in my patent, I could do what I want. So if you can live without disclosing your own confidential information, don't take on extra confidentiality obligations by having a confidentiality agreement. Get a non-confidentiality agreement. But if you can't productively work on a non-confidential basis, then we have to ask the last question, is there a possibility that someone's going to develop useful technology? And if the answer is yes, there's that possibility, a confidentiality agreement, as I said earlier, isn't what we need. We need an agreement that addresses the ownership of whatever's developed. I'm not telling you how that has to be. I own it all, you own it all, but address it. You don't want to wait till something great's invented and then you're fighting over who owns it. That's not the smart way to proceed. So when you have a confidentiality agreement or they throw a form at you, what do? Well, here's kind of the checklist. Is the subject matter well defined? Do you know what you have to keep secret, what they have to keep secret? If not, fix the agreement. Is there an express promise not to disclose? That's the confidentiality bit. It's not much of a confidentiality agreement if they don't have to keep it confidential. But also, is there a promise not to use? Because you don't want them using it, well, we can use this in our factory, we'll never tell anyone, but we're doing it. No, that's not what I wanted. Well, you asked them not to disclose, they didn't disclose. Do you need a promise not to use? Probably so. Make sure it's in there. Is there a disclaimer of liability? What do I mean by that? What if you disclose this information and their place blows up? You want to say, this information as is, if something bad happens to you, it's not my fault. That's for your own protection. Are there export restrictions? If you have high technology, encryption, something like that, you may not want this company, we sent this to our foreign affiliate to process or come up with drawings. No, you can't export this information. We're all going to jail. Bad result. So make sure you have export restrictions if your business requires them. Is the term of the agreement clear? The term, how long does this work? How long are we tied together? Everything I tell you for the next 10 minutes, everything I tell you for the next 100 years, when does the agreement end? But separate from that is how long are the obligations in the agreement? So anything I tell you in the next 10 years is subject to the agreement. Okay, now how long does that person have to keep that secret? That could be different than the term of the agreement. So make sure you understand how long the agreement lasts and how long the obligations of secrecy last. A lot of companies, particularly the bigger companies, don't like limitless obligations. So they say, it's 5 years. We'll keep it secret for 5 years and no longer. Is that a horrible agreement? Not if you're going to make it public yourself in 4 years. It's perfectly fine. But if this is something you might ever make public, then 5 years is way too short. Because what if the people who invented Coca-Cola went to a bottler and said, you know, the secret formula for Coca-Cola can be public after 5 years. The whole business would be gone. Instead, it's still a secret, it's still a valuable secret, so don't put an arbitrary period of time on it. Make sure that you pick a period of time that matches the importance of the information and how long you are yourself going to keep your information secret. And then also, you know, is there a choice of law or forum? What is this? Almost every agreement says, you know, the law of the state of Missouri controls, the law of the state of Illinois. Which state should you apply? Probably your home state, but if it's another state, it's not a disaster. But you like to know what law does apply, because otherwise the lawyers are going to spend thousands of your dollars fighting over. It's New York. No, it's Missouri. It's New York. And you haven't gotten anywhere toward protecting your information. So pick a law. And what do I mean by forum? Pick a place. Where can you sue? Where can you be sued under this agreement? It's handy to know. Maybe you can't get it. Well, it's not going to be Missouri. They won't agree to that. Well, at least you know it's Illinois if that's what they pick. So make sure that you pick your forum. And if you're dealing with a foreign entity, you want to be able to enforce that agreement here in the U.S. You don't want to have to leave the country to chase your information. So you'd pick a forum, at least someplace in the U.S. where you know you can enforce your rights. Other advice for dealing with these things, because this is probably the thing I get the most inquiries about, and I feel bad about charging my high hourly rate to answer some basic questions, but you know, start the battle of forms yourself. Don't try to fix somebody else's form. You know, there's thousands of forms floating around. Google one on the, you know, on the internet, and you'll find all sorts of forms. Some are good, some are bad, some are for particular situations. Start with one that you vetted yourself and you're comfortable with, and let them try to adjust it rather than you try to fix somebody else's mistakes. The other thing lawyers will always tell you, well, a mutual confidentiality agreement is always much better because no one will purposely screw themselves. So if they'll agree to it, they must be protecting, you know, my information as much as they want their information protected. Absolutely true. But don't just say, well, let's just make it mutual so I know I'm not getting screwed. Why take on confidential obligations yourself if you don't need to? If they're not telling you anything you need to keep secret, don't agree to keep things confidential. It'll just complicate your future life when you come up with something, you know, can we use this? Can we put this in a patent application? So just because you think you're getting a better deal, don't make it mutual. If you're the only one with secret information, you're the only one who needs to be protected. So I'm talking real fast. I hope you're all following along. It makes sense to me, but that may not be the test, is it? Yeah.
Investors, you're asking for money. It doesn't seem appropriate in many cases to have, before I talk to potential network, you know, resource, I need you to sign something. So I guess my question is, you know, based on your experience, is there a fine line between, you know, when you're discussing your idea, trying to cultivate information versus when you're, you know, in a business environment where someone may either steal your idea or whatever that may be?
Right. It's tough, but you need to keep things confidential. You cannot disclose confidential information without a confidentiality agreement. So you need to figure out what's my non-confidential pitch. Oh, I'm going to solve this problem. I'm not going to tell you how I'm going to do it and what I need to do it. You can make that kind of disclosure, and that's okay. But if you disclose the details, you're at risk. Now, you're only at risk if that person steals it. And if they don't steal it, and most people won't. I mean, I admit that. But, you know, as a lawyer, I get to see people at their worst, you know. And someone will steal something, and people will consult it. This guy stole this idea. Well, you disclosed it to him. Without a confidentiality agreement, it's not even stealing. It's just, if you say something, everything I'm telling you tonight, you can go and use because it's information. So if you make it publicly available, you run the risk that they'll take it. So you just have to be discreet yourself. You know, you have to talk to people, I understand that, but you don't have to tell them confidential information. And in fact, if you're talking to investors, I think they'll be impressed if you say, you know, I can tell you this much, but to go further, I've been protecting my IP, I know what's going on here, I need you to sign something. And if they won't sign it, keep the discussion non-confidential. Or if it's something that can be patented, make sure you have an application on file. Once your application's on file, the risk of disclosure isn't so bad. But these days, in a first-to-file system, if someone else gets hold of the information and files before you, that's the end of it for you. They will get a patent, or may get a patent, you certainly won't. So you don't want that to happen. The second aspect, because as you're growing your business, the first thing you need is, I need help. I'm stuck here. I can't do this all myself. I got to get somebody else involved. I need to hire someone. When you hire somebody, you have to take certain steps, and I think David's going to talk about this in a lot more detail. I hope so, because I am not an employment lawyer. I'm a patent lawyer. The first thing when you have someone come on board, you want them to immediately assign all the inventions in addition to agreeing to assign. So if you find a nice form on the internet, you're too cheap to hire David to do a good one for you, and you say, well, they agree to assign. Is that good enough? No, because they have to then assign in the future. You want a present assignment of those inventions. You want it right now, and as soon as they come up with it. That stops it from them assigning it to somebody else. You can just record that employment agreement. So get an immediate assignment. Don't overreach. Everything you come up with while I'm paying you anything, is mine. It's all mine. That doesn't work. There's statutes, including in the state of Illinois, that limit. No, you can only get things that are invented using company time and materials or that use company information. So there are about 6 or 8 states now that have those types of laws. So don't overreach, because if you overreach and your agreement's invalid under state law, you get nothing. You don't get what you could have had. You get nothing. So make sure that you tailor the assignment agreement to things that are legitimately belong to you as the employer, not just to everything. While you're getting them to sign something, have them authorize you to file patent applications, and maybe even have them appoint you or someone in your company, if there's more than just you and your employee, to execute assignments and things. They can actually give you a power of attorney. Why? Because if they go away, they drop dead because you overworked them, whatever, and you need an assignment to file with a patent office, if you have a power of attorney, you can sign that assignment. In this fluid workplace, particularly if it's part-time workers, they may go, you may have a falling out. I'm not going to sign anything. Yeah, you want it, but I refuse to sign. Now what? You don't have anything to record in the patent office. If you have this power of attorney and an authorization to file the things that on which they invented, you can proceed. So make sure you cover that in your agreement. And the last thing I said that I see that's missing from most of the employee agreements that I come across is control their access to your computers and data. There's a federal statute, the Computer Fraud and Abuse Act, that says you can't log on to systems improperly or steal data. And Missouri has a very good statute too. But the only way that statute works is someone does something that they're not authorized to do. And if you just say, well, as an employee, you can access the computer, there's no limitation. Then if they access the computer to do something bad, they can't be prosecuted, because the first issue is, did they have access to the computer? Well, yeah. Well, this statute doesn't apply. So you want them to agree you only have access to the computer for the benefit of the company or to do things that you're instructed to do, and you are not authorized for any other purpose. That way, if they do use your computers or abuse your computers, their acts are unauthorized. You have another tool, not that you necessarily want to use it, but you may be able to get them prosecuted, and that's how you keep bad former employees from hurting you. So those are the kind of the top things that occur to me that people leave out when they're just getting started. Of course, you want a confidentiality agreement. There's a common law duty to protect the confidences of the employer, but that doesn't mean that people live up to their duty. And when it comes time to enforce your rights, when you have a trade secret, what do you need to prove to a court? That you have information that's valuable to those who don't know it, and I took steps reasonable under the circumstances. And the judge, you go to the judge and say, this former employee stole my secrets. Well, did you have a confidentiality agreement in place? No. No. It says, how is that steps reasonable under the circumstances? Why didn't you just have them sign something that wouldn't steal your stuff? And so you want to have a confidentiality clause. Another thing that's come up recently, I have to add, is who owns your employee's professional identity? What if you say, I'm too busy, get on Facebook and create us a profile. Get on LinkedIn, and so they build a following around your company, and then they go with the LinkedIn or the Facebook password and go someplace else. Well, I want that. It was the company's. Well, was it the company's? When does online activity cease to be a company activity and begin to be a personal activity? What are their rights and your rights? If you're not handling all those things yourself, then how can you possibly? If you have other people control your online identity on any one of these networks, you need to have something in the agreement about who owns that stuff and that they have to give you the passwords. I don't say you need it in every instance, because it may chase away some good employees, but you should at least consider a non-compete clause. Don't walk across the street to our arch enemy. You can work any place else, but not for our arch enemy. Those types of clauses are enforceable in the state of Missouri, so consider having it, and keep it limited because you want people to be able to move if that's their best thing for them, but you don't want them going someplace where they can hurt you. Even without a non-compete clause, lawyers will tell you, I'm sorry, I didn't see, thanks.
Does the same rules also apply to interns? I mean, would you
Yes.
follow the same?
I would have an intern sign something too. Just because you weren't paying them money doesn't mean that, oh, well, since I wasn't paying you, go ahead and take some, take my secrets, take my inventions, So yeah, anybody who's working for your organization who has access to your information, you want to protect for confidentiality. And if they're hearing your secrets and say, hey, come into this brainstorming session, what if they come up with that's it, that's the solution? Who owns it? Well, they do, because they didn't agree to assign it, and that's the important thing. If an employee invents something, who owns it? Typically the employee, unless they were hired to invent, and good luck trying to prove that in court, or they signed an agreement that what they invent belongs to you. Well, if you don't have that written agreement, they own it. You can negotiate for it, but you're negotiating with everybody else, so you certainly need to cover everybody, paid employees and unpaid employees and interns. They need to be protected. It's your information. You have to take steps. And then finally, you might consider a non-solicitation clause. That's just a clause that says, if you go, don't take everybody with you. You can't solicit your other co-employees. I'm not saying you need one, but think about it. Make sure that if you don't have one, it's because you thought about it and it was the right thing to do, not because I didn't know there was such a thing. These are going to be a little bit repetitious, but maybe you decide, I'm not going to hire an employee. I don't want to handle the paperwork. I'm going to hire consultants. Is that any better? Not really, but you still have to take into account the same effects. Get an immediate assignment of that consultant's work product. Take into account that if you hire a consulting company as opposed to people, that it's your job to make sure you get your paperwork right. What do I mean by that? Well, if you hire a consulting company and they agree, oh yeah, we'll sign everything that we invent to you, but the consulting company doesn't do the work, it's their employees who do the work. And so if that consulting company doesn't have the right paperwork in place with their employees, no matter what they invent, you don't get it because they can't make their employees assign it over because they didn't do their paperwork right. So your agreement with the consulting company, you need that company to represent that. They have agreements in place, with their employees, and if they don't, that they're going to make it good, they're going to pay those costs, they're going to get the lawyers to make those employees turn over those inventions. So if you're dealing with a consultant who's an individual, you can treat them as an individual and contract with them. If it's a corporate or LLC type of consulting company, you need to make sure that they've done their paperwork right, because a lot of consultants are really good at consulting, really bad about handling the legal side of it. And again, you may want to present, just like in the covenant not to compete, you may not want your consultant learning a whole bunch on your nickel. You're paying them a whole lot and solve your problem, and they think, wow, this is a solution we could sell to other places. Oh, no, it's not. You can't work for the companies who compete with us. You can work for other companies, of course, but make sure that you protect yourself from competition from these people that you've enabled with your information. Your inventions. We heard from the patent lawyer, and he gave some great advice. In the world today, you do not disclose your inventions outside the company unless you file a patent application. I mean, if there are exceptions, well, I can't afford to now. Okay, but you're taking giant risks these days. This is a first-to-file system. So if you make any disclosure outside the company and that ends up in somebody else's patent application, you may not be able to get a patent. Well, I invented it. We don't care anymore. The poor man's patent that was mentioned earlier, oh, I can prove I invented it first. Good for you. Maybe we'll give you a trophy. But you're not going to get a patent unless you're the first person to file the application. There's some limited exceptions, but as soon as you're talking exceptions, you're talking money when lawyers and expense and lawsuits. So before you disclose any technology, patentable technology outside the company, you really need to get a provisional patent application on file or a regular utility application, but get a filing date for that information. And make sure that you have written agreements with everybody in the room who's working on it. Consultants, what's your agreement with that consultant? Friends, interns, as the question was, employees, anybody who could contribute to that invention needs to be signed up. You can be any deal. I own it all, I promise to pay you something. But make sure you know where those rights go and that it's under your control. Otherwise, if it's not under your control, it's not yours. Let's talk quickly about trademarks. Everyone wants to brand their product, and everyone, like my experience, when they come up with a great idea, I've already got the perfect name for it too. My first rule on dealing with trademarks in startup businesses and entrepreneurs, don't fall in love with your mark until it's been fully vetted, or you'll make a bad decision along the way. You'll say, you call up the trademark lawyer, look, can you do the search? And they come back and say, yeah, we found something. And you're thinking, oh, but that's for left-handed people. Mine's for right-handed people. We can go ahead and use this mark. No, you can't. But why do you say something like that? Because you love the mark. Oh, it was the perfect mark. I want to do this. So don't fall in love with those marks. If the trademark lawyer says this is an iffy mark, let's move on, move on. No matter how much you like it, you're going to spend more money on lawyers than you want to if you don't cut your losses early on. Search your marks early on to avoid wasting time. Don't fall in love with a mark. Do all your business plans and all this. We're going to call it this, and find out that's already been registered to somebody. Did you have a question?
Yeah, on that point, searching for the trademarks, actually on the USPTO site, there's 6 different databases that they say potentially go through. It has the trademark, the TESS, design search code, US registration, all these things.
Yeah, just go to the regular, go to the USPTO site, up in the top right hand, search trademarks. And then go down to the third box. I do this like 10,000 times a day, where you do the advanced search because the other ones just irritate you. And search in there, and if you're searching for a word mark. If you're searching for a design, then you need to search the other. There's different information, but that's really the best place to search. Yes, Christian?
Would you tell us the name of that site and where?
Sure. The U.S. Patent and Trademark Office website, which is www.uspto.gov. And you go there, and the top right, there's a search patents button and a search trademarks button. So search your mark and make sure it's available. Yeah.
They don't have any crawlers out here, do they? Figure out if you search what term?
Google does, and a lot of other databases do, but the patent office isn't organized enough to do such a thing. So that's why, yeah, you're relatively safe doing there. In fact, well, I think you need to do a Google search because this will tell you if there's a registered trademark or someone's recently applied for that trademark. But it won't tell you that someone's been using it for 20 years and was just never bothered to get a registration. So a Google search is just a necessary evil to clearing it. But if you do one search, I don't know how high up you're going to get on the Google hit list.
I'm just talking about the people that figure out, okay, what string did they use? It's like, oh, that's a trend. I'm going to go buy that, right? And they charge it for it.
Right, and I know that happens on domains, or at least used to. But I think that you do need to vet your trademarks. You just have to. So as I said, Google marks to find potential conflicts, and just to understand the public perception. Sometimes you'll do a search and you'll find, oh my gosh, it means that. I mean, I do this elaborate trademark presentation, and one of the things that sticks in my mind is Reebok came out with a woman's running shoe called Incubus several years ago. And if you've done any literature reading, Incubus is a demon who attacks women in their sleep, rapes them in their sleep. What a great name. Now, when they did their trademark search, look, no one's using that. Well, I wonder why that could be. It says, oh, that's right. It's a demon who rapes women. What a great name for a women's shoe. So make sure you understand what your mark means, too. Avoid merely descriptive marks. Oh, but I want my mark to tell people what it is and what it does. Those are the hardest to protect. One, there'll be thousands of others like that out there. And two, when someone else wants to join in, they see your product, they can call it something descriptive. I'm allowed to describe my product, and the courts aren't going to stop me. So if you pick a descriptive mark, you're just not going to have protection. Make your marks, your advertising, and your packaging distinctive and consistent. Build yourself an identity. We're the company that has the pink letterhead. We're the company with this font. What is your identity? Think about your identity and build it up. That's how you build up strong trademark rights. And then register your trademarks as early as you can. You can file based on your intention to use because you want that name locked up and as soon as possible, because people will come close as they can if they're trying to compete with you, so they can suggest to people, oh, we've got a similar product. You don't want that to happen. I'm buzzing through my time here. Copyrights. Another area of intellectual property is copyright. This should be your favorite one because it's substantially free. You don't need to pay lawyers anything for this. You have copyrights in all the works of authorship, which is just about anything copyrightable. As soon as you fix them in tangible form, write them down, save them to a hard drive, poof, there's a copyright. No money? Don't have to talk to a lawyer? No, you don't. You know, we're left out of this equation. You can do, there are two things to do. The first is put copyright notice on every copy so people can't claim, well, Your Honor, I didn't know it was copyrighted. They should know, and that innocent claim doesn't really get them anywhere, but you just don't want to make it. Slap copyright notice on it. It just seems fair to the court. And you can get a registration. If you do your own taxes, you can get your own copyright registration. I honestly feel bad getting people copyright registrations because at my hourly rate, they're blowing $200 and $300. They don't need to blow if they've got half an hour to go to the Library of Congress website, you know, loc.gov, libraryofcongress.gov, find the copyright site and fill out the online form. If you need help, then that's fine. But after you get one done with a lawyer, if you can't figure it out, you're probably not going to succeed anyhow. Yeah.
On the copyright, now this will include schematics, mechanical drawings and stuff like that, or is it just primarily literature?
It's any work of authorship. So drawings, photographs, mechanical drawings, technical drawings, just illustrations, words, text, movies, videos, YouTube videos, pictures, I mean, computer programs, everything. You know.
Can that be used to protect, say, somebody who is getting ready to patent your idea, and even though you have a copyright from 2012 on it, and now here's somebody stole your idea?
No, because we don't care when you invented it, so the fact you had it 2 years earlier, right, first to file. And second, it's only copyright infringement if they copy you. So if they independently come up with the same thing, I didn't see their drawings, I just made the same product or copied their commercial product, it's still not copyright infringement. They have to copy the copyrighted work. So, you want to acquire copyright in your packaging, all the literature, see in the circle, throw it liberally around. There's no penalty for putting it on something that's not yours, although I don't recommend it. And make sure you acquire the rights you need. I don't know if my next slide, I want to go back. And I'm not going back. Let's go back to copyrights real fast. So if an employee creates a work, unlike patents, if an employee creates a work in the scope of their employment, you as the employer automatically own it. You don't need a written agreement, although it never hurts. But if it's a non-employee and a consultant, so someone you don't fill out the W-2 forms for and all that, they're not a technical employee, but I paid them. Well, I didn't ask if you paid them. I said, well, they're your employee. If they're not your employee, you don't own anything they create except what they give you. So you need an agreement with a consultant that says, if you write code for my project, I own the copyright and not you. And you agree to assign it, and hereby do assign it. So if you have people come in an advertising agency, and they do take some pictures because I need a new picture for my beautiful new website. They take a beautiful picture and you like it. It's on the website, pay them good money for it, and say, this is so good, I'm going to put this on my presentation to the company X. You don't have the right to put it on the presentation for company X. You didn't buy the copyright. You bought their work to create you a website. And if you do anything else other than what was originally agreed with it, if you don't own the copyright, you can't do that. So you need to, I'm not saying you need to acquire all the copyright and everything people do for you. You need to acquire all the rights you're going to want to have. And how do you know what those are? Well, the safest way is to acquire all those rights. But if the photographer says, no, I'm not going to give you it for all purposes, well, at least all my advertising, not just the website. You need to be careful that you acquire all the rights you're going to need for when you're dealing with third parties. For employees, you don't have that problem, but it's only technical, true employees, not people who you just manage to pay. So yeah, sure, I'm sorry.
Could you, what additional benefit do you get with filing that online form on the Library of Congress?
Okay, you get some pretty good benefits. There are two big benefits. First is, if you can't prove you've been damaged, what do you get in a copyright case? Nothing, you weren't damaged. If you have a copyright registration and they infringe it, you're guaranteed a minimum recovery of $500, and the court can award up to $150,000 per infringement. So you get what they call statutory damages. So you're guaranteed you're going to get something out of it. And the second, and probably the biggest remedy, is that if you have the registration before the infringement begins, then if you sue and win, the other side has to pay your lawyers. Now, no one likes to pay damages, but I tell you, people really don't want to pay lawyers. And they don't want to pay the other guy's lawyer. That's like insult to injury. So while they may pay their own lawyer to defend themselves, you mean I've got to pay that jerk too? not happening, those copyright cases settle. So if you have the registration before the infringement begins, you write a letter, you're subject to statutory damages and attorney's fees. If they know they've copied, they go away. Oh, I'm sorry, what do we have to do to make this right? Because we're not paying 2 sets of lawyers, you know. So that's what you get, and so it is important to do that. For every work, yeah, it's $35. Is it really going to break you? You know, and some say, well, you can register as much as you want in one work. You could say all, you know, the marketing materials from 2014. But the more you glom together, the harder it is to prove infringement. If they copy one paragraph out of one page of a 500-page work, is a court going to be impressed or think that that's really copying? Maybe not. It may get so small. So you're best to pick important works and go ahead and register those. Your packaging and things, you know.
If you register, are you able to put something different on your copyright?
No, it's just see in the circle, see in the circle, the name of you want your copyright notice, see in the circle, copyright owner, and the year of first publication. And you can put anything else. This has been registered, you know, the FBI won't like you. You can add all those things. They have no official weight, but, you know, if it makes you feel better or it might scare someone, do it. Yeah.
So how long the copyright lasts?
Oh, forever. I mean, the life and being plus 70 years. So, so past you're dead and probably your children are dead and maybe even some of the grandchildren. It's almost ridiculous how much more protection we give copyright than patents. I mean, someone can invent and patent a cure for cancer or something that's really important, or you can draw a Mickey Mouse cartoon that still isn't in public domain. So it's a long, long time and far longer than you're going to care about, to be honest. Yeah.
Your company name, in the .com world, you realize registering the .com using your company name. Would it be beneficial to go ahead and copyright your corporate name?
Yeah, you can. Yeah, that would be the area of trademarks. You protect your brand. Copyrights can't protect short phrases. It has to be long enough to be considered a work of authorship. So I don't know exactly how many words that is, but it's more than just a company name. That's pretty well established. So trademark is for company names. Oh, question in the back.
What about your logo? It doesn't have a name.
The logo is probably also best registered as a trademark because it's a brand thing, but if there's a substantial amount of artwork to it, you might as well claim your copyright too. It's just another way to go after somebody. To sue someone for trademark infringement, you have to prove that what they're doing is likely to cause confusion. Not that it actually caused confusion, but it's likely. But that's harder than just proving they copied. Your Honor, of course they copied. Look, they look the same. That'll win your copyright case, but proving likely to confusion, there's a little extra work. So might as well have 2 ways to sue somebody who's trying to take your stuff than just one. Okay, so that's copyrights. Just 3 more points, and in like 9 minutes. Advertising. Look at your you need to promote your business, get out there, all your advertising and promotion materials, your web content. First point is make sure you're ready to disclose that content. Don't, particularly in this first to file environment, put something in your website or your brochure that tells people what the solution is before you've got that patent application on file, because it may not bar you from filing, but it may help someone else bar you from filing. Your own work that you publish within 1 year when you file your patent application isn't prior art, to you. It's to prior art to everybody else. But if someone reads that disclosure and says, oh, that's what this guy's up to, and writes their own application and covers what you've got, that won't stop you from patenting the basic idea, but they could patent all the obvious variations. And then you can paint it blue, and then you could add a bell to it, and then you could do this. And then when you try to get a patent, you can get only a patent on the narrow idea because that's what you publish first, and none of these obvious improvements. So you ruin your own protection if somebody's out there watching and trying to patent around you. I'm not saying there are people doing this, but you don't want to lose protection because someone republishes or thinks about, oh, that's a good idea, and what about this and this? They may do it completely innocently. But if you haven't filed, they've blocked you from all those obvious improvements because you didn't file before you made it public. So don't stick stuff in your advertising till you're absolutely confident, yes, this can go public. You're rushing to that trade show, oh, we got to make a big splash. You better make sure you talk to your patent lawyer before you do, because you may put a whole bunch of people who are really interested in your idea on notice, and they'll be filing a whole bunch of things before you do. So you have to be careful. Make sure that you're using your marks properly. Trademarks are adjectives. If they're unregistered, you can put a TM by it. If it's registered, go ahead and put that R in the circle by it. Make sure they're distinctive, and you don't, if they're somewhat descriptive, don't use them in a descriptive way. The worst thing that happens, I find, is that clients in their advertising pick a descriptive mark, and I said, I really wish you wouldn't do that. Well, it's arguably descriptive, but then they use it in the text and use the trademark as an adjective to describe what they're doing. So now the trademark examiner has no choice but to reject us because over your own stuff, you made your mark unregisterable. So make sure you use it as an indicator of it's your product, not a describer of the product. Make sure that you have adequate rights to publish the advertising. Don't go right-clicking pretty pictures off the internet to make your website look better or your brochure look better. You will be found out and you'll be sued for copyright infringement. And if they registered it, you're going to be paying somebody else's lawyer. And I told you, you don't want to do that. And then make sure you protect your advertising. All the marks should be searched and registered and properly marked. Put copyright notice on it, and if it's something you're worried if you'd be mad if someone would copy it, it's worth the $35 to go online and register that copyright. It's just not that hard. Okay, life in a first-to-file world. So for 2.5 years now, we've been in the, well, for a year and a half, we've been in this world where first person to file or disclose gets the patent. And so we no longer care when you invented it. It doesn't help or hurt you at all. So you want to avoid disclosing your invention outside your company until you get that filing date. Otherwise, people will start chipping around and disclosing obvious improvements and limiting what you can patent. Keep invention records. And everyone goes, what? So this whole point of first to file was we didn't have to keep track of all this stuff. Well, you may need to keep track of it, particularly your records of disclosures to others, because one exception is that if something's out there and you can prove that you disclosed it to them, that doesn't count against you because it was derived from you. Well, how can you prove that you disclosed it to them if you don't keep track of who you talked to and when you thought of it? So if there's a fight over whether this was derived from someone else, you still may need to prove your independent creation. Even though we don't care when you did it, we do care that it was independent. So sadly, even this, that, oh, I thought I didn't have to keep records anymore, you still have to keep records of your invention, and particularly, add any disclosure you make outside the company, even if it's with a confidentiality agreement. You may need to figure out how this got out there. I think that you should serially file provisional applications to get a priority date for all your significant developments, and then you roll them all up into an application at the end of a year. So we come up with this great idea. You file a provisional application today. A week later, you come up, oh, but here's a great improvement. We'll use this. File the same provisional, add the little improvement to it, and get another filing date. You can get as many filing dates as you have $200 fees to pay the patent office to file these things, and at the end of a year, you roll it all up, and you want the earliest filing date for each significant development because it's a race to the patent office. No one cares you thought of it first. It's who has the earliest filing date. So keep any significant development should get a filing date. This is the way it is now. If you decide how we just don't have the money or we're not going to turn this into a patent, you still, if you filed a whole bunch of provisional applications, need to figure out, well, I need to get this thing to publish. Either turn it into an application even though I don't really want to, so the patent office will publish it, or put it on your website, because if you're not going to pursue it, if you bury it, someone else can come along and patent it. And then if you want to resurrect it, say, well, Your Honor, I invented it first. And he'll say, didn't I tell you? We don't care. It says whoever filed first gets it. So if you haven't made it public, it's not prior art, and leaves it open for someone else to come along and invent it and take it out from under you. And it's really galling to say, wow, I thought of that, and this guy has a patent on it, and now I can't do it because he got a patent on what I disclosed. So if you're going to abandon applications that haven't published and you haven't otherwise made the invention public, poison the water. Don't let someone else come along and patent it. So go ahead and make it public. Publish your invention if you're going to abandon it, and you can either write a journal article, put it on the internet. Yes?
What was that legislation that made this the first to file?
The American Invents Act that took effect in, the first to file regulations took effect in March of 2013. Was when we switched over, March 16. So before that, it was a first to invent world, which is really better for individual inventors. The first to file didn't help anybody, but they sold us all a bill of goods that it did, and now that's the system we're under. So you just have to deal with it. You can't change it, you got to deal with it. The last, I'm sorry, go ahead. No?
So before we've had, I guess depending on the idea, especially if you're in a kind of a busy, aggressive market, you might do what is it, the freedom to operate or whatever, like that type of search, right, to see if you can, even if you do patent something, can you do anything?
Right, and that was Bob's point, that getting a patent doesn't mean you can do it, it just means you can stop other people from doing it.
Generally, it seems like you want to do that my question is really more about the time, like how long does stuff like this usually take?
It depends on how complex the invention is and how fast-moving the art is. I mean, you can do your own freedom to operate searches, or at least keep track of what's going on in your own area. You should. If you're thinking of filing a patent application, you probably ought to see what patents in your area look like. And no matter what, if it's an ashtray or something simple like that, you should know about what ashtray patents look like and who's inventing them and what what standards. If it's some DNA assaying device, you probably ought to look at a couple other patents, just so you know how this patent scheme works. What do they look like? What's in there? Who are the active people? But a patent lawyer can do a patentability search or a freedom to operate search in less, a month time is more than enough time, less if you have some deadline to meet. But you need to keep track of what's out there, what's being published. And, we keep a watching for our clients, and you need to for yourself. Who are the big inventors in this area? What are the big companies? And just periodically, patent applications are published every Thursday. New patents issue every Tuesday. What happened this Tuesday? What happened this Thursday? Are any of the companies we're concerned about, publishing things? And I have a huge list of watches that I go through every Tuesday night and every Thursday night to see if they relate to my clients. And if they do, I send it to them and hopefully get to charge them for it. But your lawyers will keep track of that, trolling for business. It's the best way to get free service.
If I come to you for an application for the patent and stuff and have you guys do it, who does the artwork? Your office or because I've looked at the format on these patents and they make your mind spin.
Yeah, the drawings are tough. We will work with the inventor if their drawings are good enough, and we think that the quality is good enough and they'll pass the patent standards, and you can save $100 to $200 a sheet. Or you can just hire it out to a whole bunch of professional drafters. We have probably 8 or 10 companies we work with, and they charge $100 to $200 a sheet. So if it's something simple, we think you can illustrate in 2 or 3 sheets, you're saving $600 trying to write good patent drawings. It's best just to let professionals do it. That's my opinion. But if you really want to save $600 and don't mind drawing the lines to the right thickness and make sure the character heights are the right character heights and all the other crazy little rules the patent office has. You can't crosshatch, you have to shade with lines, you can't have grayscale. I mean, if you want to follow all those rules and you can do it, we'll work with those. Any patent lawyer will work with those drawings.
That also applies to the verbiage too, because I've read about item number 101.
The verbiage is really, we jealously guard that. Bob said it, and he's absolutely right. Don't try this at home, boys and girls. These are trained professionals. You can absolutely describe your invention maybe better than I could. At least you'd have more of the nuances. But I am confident I write, and Bob feels the same way. We write a better description that's not going to be attacked legally. There's some things you just can't say. Things like, important to the invention. Oh my God, no patent lawyer would ever say important to the invention, because that means that has to be there. What if someone figures out how to do it without it? I mean, we're constantly worried about the scope of the claims and how things are. So we jealously guard writing that. We will work with people. If someone insists, I wrote the whole thing, I just want you to look it over and file. If it's not horrible, we might participate in that, but we don't like to have our name on something like that because something bad's going to happen. The Court of Appeals for the Federal Circuit that handles these patent cases is all over the place. And we read these decisions, Bob, people like Bob and I, we follow these things and try to make sure we keep our practices up to date. And we're trained professionals. Don't try this at home. Yes.
So I have a business, let's say, with other countries,
Mm-hmm.
and I want to protect my trademark in that country. So how can I protect my trademark in other countries?
To protect a trademark in other countries, it's like the patent system. Every country has their own system. The only exception, there's some I think you can file a group trademark in African countries, but no one does because the economy doesn't justify it. There's a European trademark. You can file a single application, cover all of Europe, and after that, it's a country-by-country basis. If you want a trademark in China, you have to file in China. If you want a trademark in Japan, you have to file in Japan. If you file your trademark here, you have 6 months to file in all the other countries, essentially all the other countries, and they'll backdate your application to your U.S. filing date. After 6 months, you can still file, but then they're going to give you your actual filing date in that country. They're not going to backdate it. So if you think, I need rights around the world today, file a U.S. application, and then file in the rest of the countries within 6 months.
So then what is the average cost for?
The average cost per country is about $1,000 to $2,000. The English-speaking countries are a little bit cheaper because there's no translation, you know, but so Japan could be $4,000 or $5,000 with translations and higher fees and government fees. So, but the average is to about, you know, I'd say 2 is a good average, you know, $2,000 per country, unfortunately. The last point I wanted to make, oh, I'm sorry, did you?
Just want to ask, is the international patents or country by country, is it different, the format, or it's almost the same?
No, I mean, we prepare ours to travel pretty well. The one thing that we do sometimes in the United States is we'll cross-reference other US applications or incorporate by reference. Most other countries hate that and make us take that out. But other than that, our sections generally correspond, claim structure generally corresponds. So a good patent lawyer in Europe writes an application that travels pretty well. A good patent lawyer in the United States writes an application that travels pretty well. So the last point, and I think this is really important, so I want to make it even though I'm now 3 minutes over my time, I apologize, is email. The worst legal problems seem to come from people's emails. So when writing emails, and actually it's not emails, it's when you're creating exhibits for the inevitable lawsuit, follow these rules. Keep your business email professional. Pretend mom is reading over your shoulder. If your mother would be appalled, so would the judge, so would the jury. Don't do it. Now, if you need to, as I often need to, write a whole elaborate email and speak your mind, and then delete it, good. But don't send those bad emails. They will just count against you. Consider the purpose of the communication. Why am I sending this? Don't divert from your purpose. Unless your purpose is something like, I want this guy to feel really bad, that's probably not a good reason to send your email to begin with. Consider the audience and the recipients, and when you're considering that, it's not just the person, the addressee, it's going to be marked as an exhibit. Some jury, oh, he used a bad word, you know, or the judge is thinking, whoa, what a jerk. You know, you don't want people to think that about you. Be factual. You know, if you're truthful and factual, no one can debate it, right? If that's the case. Where an opinion's called for, say, well, in my opinion, this is what should happen. Don't make sure it's germane. Don't just give random opinions, you know, about things, and never give a legal opinion unless you're a lawyer. So don't say, I think this is an infringement. You have no business giving that opinion, and it may come back to bite you in some way you don't know 10 years when they dig this out of your email trail. Unless you have a system like the IRS where you can delete your emails much more effectively, most of the rest of us haven't figured that out, so they'll find them. You know, we're persistent. Lawyers are really expensive, but we're really persistent. We'll search for documents to the last dollar you have. So further, don't make mean or demeaning references to others. Oh, the fat guy was here today and he has a stupid idea. It's just, you know, if you got a fat juror, you're doomed. And the odds are the judge is going to be a little overweight, so you don't do it. Make your point, but avoid extreme emphasis. Don't underline things, don't bold them, don't put exclamation points. I mean, really, how many exclamation points do you need? I had a client who was deposed for 35 minutes on why he put an exclamation point at the end of a sentence. Because, oh, this was important, wasn't it? No, I put an exclamation point. Well, do you usually put exclamation points? I had to listen to this nonsense going on and on about exclamation points. Don't do it. Put periods. They work just fine. Keep your business and personal messages separate. You never know what personal thing you like is going to be appalling to somebody else. Oh, you know, let's file this application right away and let's meet at Hooters for lunch. You never know what juror is going to be upset at such a thing. So if you want to invite someone to lunch, keep it entirely separate from your correspondence about filing your patent application. And just think how you're characterizing the company and its activities. You know, so, you know, we need to make a competing product with this company. Our rip-off of the so-and-so company, or our knockoff of the so-and-so. Oh my God, no. You know, it's going to be marked as an exhibit, and you're going to be deposed. Don't say bad things about your company, even if you feel them. You know, and sometimes you get frustrated, but just think that everything you write is going to come back to haunt you, and this will save you in your IP litigation and your other litigation. So that's really what I wanted to cover. There's a lot more in the owner's manual. Hope this was helpful to you, and thanks for your attention.